All right, welcome back to the program. And like I said, we really do not take your company for granted. We want to start our conversation this morning looking at the state of the judiciary. And of course, I told you we'll be having a panel of four, a lady and three gentlemen. And already in studio, I'm having this morning Julie Wayua Madheka. Julie is the Program Manager, Democratic Governance at ICJ Kenya. Thank you, Julie. We also have with us Wakili Duncan Okach. Of course, he's an advocate. I can't say your name without saying Wakili. Karibu sana, Wakili.
Thank you, Safin.
And of course, we're expecting Murigi Kamunde. He's an advocate. Kamande, he's an advocate. And we also will be joined virtually by Agri Juma, Senior Manager at the International Justice Mission. Of course, this conversation coming just a few days on November 15th. The judiciary released its annual report. That's the State of the Judiciary and Administration of Justice report, an event that happened at the Milimani Law Courts right here in Nairobi. There were key highlights on some of the steps that the judiciary says they've gotten right in terms of even the case backlog and all that. But of course, there were key concerns on the issues of funding. And of course, there have also been concerns about how the judiciary itself has been conducting its work. We know what the LSK has been saying about concerns of corruption, and those are all the issues that we'll be talking about, looking at the complexities they present when it comes to delivery of justice to Kenyans. So allow me, gentlemen and lady, begin with you, Wakili, just before we even look at the specific numbers of how the judiciary fared in the last financial year. In your day-to-day work, of course, you interact with what goes on along the corridors of justice. What would be your general assessment of the state of judiciary as we sit this morning?
Thank you so much, Safin. As I answer your question, let me first pass my condolences to the judiciary and to the legal fraternity at large for the loss of one of our own, Dr. Wilfred Mutubwa, yesterday. To the extent of your question, my view is that we must call a spade a spade. Mm-hmm. The judiciary still has a lot of teething challenges, which, of course, every institution, any organization would always have, because perfection is a moving target. And to that extent, there are those challenges which we still encounter day to day. However, we must also appreciate that there are several strides that have been made in due course, which have made it easier to access justice in this country, and have facilitated and made it a bit cheaper, have facilitated access to justice in a manner that we will be saying that there is gradual, steady improvement. We may not be where we would want to be in terms of the ideal situation, mm-hmm. but there are concerted and deliberate efforts being made to improve access to justice and the administration of justice in this country.
Mm-hmm, mm-hmm. Yeah. Probably from your end as well, looking at the judiciary this morning, as a player and of course also as a Kenyan, how do you assess how it has performed in the last financial year?
Thank you very much, Safin, for having us. I represent the International Commission of Jurists Kenyan section, and one of our key mandates is upholding democracy, rule of law and human rights, and as such we engage quite frequently with the judiciary because of its work in administration of justice. From where I sit and looking at the state of the judiciary report that was released the other day, mm-hmm. I do believe there are remarkable improvements. We have to appreciate that the judiciary has attempted to actually cover the entire country in terms of having accessibility of courts. There is still a challenge in regards to one high court not being there in one county. But in terms of coverage of the country, there has been deliberate attempts. We find that even the mobile court system that they have deployed has reduced the amount of distance traversed by a Kenyan to seek justice to about 80 kilometers, with the farthest being 230 kilometers. And if you really go back as to where the judiciary came from, give or take 5-6 years, people used to travel quite a significant distance to get access to a court. So I do believe that there is remarkable improvement in that regard. Also appreciating the fact that in this particular strategic plan, which the judiciary launched under the Chief Justice Martha Koome, the Social Transformation and Access to Justice Plan, STAJ, she has been very deliberate about ensuring the multi-door access to justice, which is basically ensuring that you have various forums where you canvass your issue and get access to justice. She has been very deliberate about ensuring that court-annexed mediation is featured in a lot of the courts in the country. Same to the Small Claims Court, which has actually unlocked billions of shillings for persons who are actually having small matter litigations before the court, and as well as improving the issue of access to justice through alternative justice systems. The judiciary has been quite strong. And I believe as we speak right now, they have just launched another Ukumbi in Marsabit. So there is also a deliberate way of ensuring that judiciary is not only offering access to justice through its stricto sensu legal courts, but they're also opening up other avenues for access to justice. And this particular report, the SOJA report of 2023-2024, was the first report that actually documented demosprudence, which is jurisprudence from the alternative justice system. So I do believe that there are attempts, they are making advancements, but as you rightly said, there are challenges. One of the challenges that this report clearly highlights is the fact that the judiciary once again was not funded at the tune of its request. It requested for 43 billion, it got 22 billion. So as such, it was operating at around 46% capacity in terms of financial capacity. But also talking about human resource capacity. The staff complement that the judiciary would aspire to have, they haven't met it. They have been operating at around 40%, 50% capacity. The only court that is actually resourced to 100% capacity is the Supreme Court, because the Supreme Court has 7 judges and indeed all 7 are there. However, for the other courts, down from the Court of Appeal to the magistracy, they are not operating at an efficient capacity, and as such there are challenges in regards to access to justice due to also the workload that is there for the justices.
Yeah, that's true, because the Chief Justice actually cited an example of the Court of Appeal that needs about 70 judges, and now they're operating at, is it 29 judges? Wakili, from where you sit, how does this impact? This is just an example. If you go even to the issue of the shortage of judges is something that is not new in our country, and it's sort of like a song that we continue singing over the years. How does this affect the delivery of justice in our country, the human resource, crisis at the judiciary?
I saw the president was one of the key speakers in these years' inauguration of this particular report. And one major issue was that issue of funding. Indeed, the JSC had rolled out advertisements, had even shortlisted candidates for the positions of Court of Appeal judges. Shortly thereafter, there was an indication of lack of finances, and that process just ground to a halt. To that extent, of course, it means that if we do not resource the judiciary, then it will also be a fallacy to expect, optimum performance on the other end. We then deprive ourselves the right to actually point fingers, blame, or lament. So it is important, having appreciated the key role of the judiciary in the country's transformation and development agenda, it is therefore important, and it behoves the executive and parliament too, to ensure that the judiciary is fully resourced. And in any case, if you look at the judiciary itself and even this report, judiciary also contributes in a large way in terms of the money that goes into government, and it is captured in that report. So it therefore means that in terms of efficiency and ensuring that we have a proper functional judicial process that promotes access to justice to the optimum standards, then the aspect of financing comes first. With that one, you can easily resource in terms of human resource, in terms of any infrastructural development that is required. It can easily tap into that.
All right.
But if you look at it currently, the reality on the ground is that the Court of Appeal has become a bottleneck, whereby we have so many High Court stations, and matters from the High Court will be appealed to the Court of Appeal. Therefore, you find that you have, it's actually a pyramid kind of, whereby ideally a lot of cases will go up, but we'll find that we do not have the proper infrastructure to handle those cases. Therefore, it leads to a lot of backlog. And you saw a very good example in the lamentations that were there in the dailies just a few days ago, where a case from 1992 was just being dealt with fully the other day. So it tells you, do you have that patience?
Yeah,
you know,
how long it takes.
How long it can take, even for a normal Kenyan and a normal Holoipoloi to actually just decide that I will have faith in the judiciary and take my matter to the judiciary, when you are going to get your judgment when you are old, or even when your estate is actually being dealt with by the same judiciary. All
right, and just from where you've stopped, I want to rope in Aggrey Juma. Aggrey is joining us virtually. He's the senior manager at the International Justice Mission. Aggrey, you've heard what Wakili Okatch has shared with regards to even an example of that case that has taken decades. And as we look at the state of judiciary this particular morning, would you say that we have, as a country, fully delivered the constitutionally protected right of access to justice to every Kenyan, you know, with the current context and the way in which our judiciary operates as at today?
Thank you for that important question and for the opportunity of this important discussion. I think in regard to the question that you've asked around the issues of access to justice, number one, as a country, we are facing a challenge generally of backlog, as has been mentioned by Wakili. And as we speak right now, the duration of time it takes for a case to be finalized is quite significant. And as we say in law, justice delayed is justice denied. And this is affecting the public's confidence when it comes to pursuing justice through our court system. And so if you look, for example, at the coast, where we have so many cases of sexual violence against women and against children, the community is opting more and more to pursue alternative approaches to justice for sexual violence, for example. And so the upsurge of what we call kangaroo courts is very high here in the coast, because the public is seeing the speedy approach in which these kangaroo courts are delivering justice for members of the public. And so they prefer that instead of taking a matter to court, which might take at least 3 to 4 years for it to see anything close to a conclusion. And so the issue of backlog of cases, which I think as at now, according to NCJ report, is over 300,000 cases pending in our courts this year, I think is a serious issue, which we need to look at and see how we can address it so that we do not have cases taking excessively long when they come to court. And so it's a very important discussion, and it is something that is serious, which we need to look at as a nation with more focus.
All right. Thank you, Juma, for saying that. Of course, the judiciary reports that there's been a slight decrease in the case backlog. We'll be looking at the numbers shortly, but having joined us also is Murigi Kamande, an advocate. Murigi, karibu sana. We were just opening and looking at the general assessment of the state of the judiciary, and also borrowing from the report that was just unveiled on the 15th of November this year. I would like to hear your thoughts as well. What are your biggest concerns?
In Swahili we say mgala muwe na haki umpe. I'm a consumer of justice, and an active participant in whatever happens as an advocate of the High Court of Kenya. And I would wish to applaud the judiciary. You know, we might think every institution has its own challenges. Yeah, and when I came in, Okatch was giving us that example of the succession matter that has taken since 1992. And which has led to various complaints at the Judicial Service Commission of the way that matter was handled. But if you look at the last, say, 5 years, there has been an improvement in terms of case backlog, in terms of how long cases are taking in court. I'll give you an example. There are those matters right now that you are filing, and by the time you file, you have a date for purposes of the matter being mentioned to confirm whether parties have complied, you do not do those mentions over and over again to see whether parties have complied. Within, say, 3 months, you have a hearing date. However far it is, you are sure that your matter is going to be heard. Some matters are taking, if you have divorce causes here at Milimani, divorce causes are taking a maximum of 1 year. Within 6 months, that ordinarily that matter should be heard and determined. So I believe there is a positive. Positivity coming from the judiciary. There has also been an increase in access to justice. For some of us who've been complaining in Nairobi about cases and backlog, you go to a court like Makadara, you have so many cases, you have, let's say, even if you have so many judicial officers, you have a cost list that runs up to almost 30 matters. So you see a situation where matters are moving. Even if you have far dates that you are being given, then you can see there is movement on that front. And also, you also have to applaud the establishment of various courts that you've seen in Nairobi and in certain areas. Right now, we have 2 high courts that we didn't have in Nairobi. We have a high court in Kibera. Recently, we have a high court that has been established at Makadara, even if it has not been operationalized. There is a magistrates court that is it at Dagoretti, to ease the backlog at Kibera. You see, when you practice in these courts, that's when you realize what case backlog is all about.
Really means.
Yes, you might think you've gone to court with only one file, and you'll spend an entire day at Makadara or even at Kibera. There are people who you will find have been in custody for 5 years because their matters are never heard. The only thing they come to do, they know inakuwa ni kuitika. They have mentions over and over again. So in that front, when you have that access to justice, you have more courts that are being opened, then I think it's a positive thing. But still, you have issues that still bedevil the judiciary as we know it. I know of issues of, say, corruption. I wouldn't want to say outrightly about corruption, but you'll hear complaints about matters where, especially in land matters, where people will complain that some judicial officers have been compromised so that they can give decisions in a certain way. Right. And so what you're left to is to just go and appeal, provided it is it is independence on their part.
All right. So there are issues that thwart the judiciary's effort to deliver on its mandate, we agree. But then again, you're also citing that even internally, there needs to be a cleaning of the house.
Yes.
We will talk about those issues. But Okachi, you had something to weigh in?
Yeah, I think it's just on those issues. You know, my colleague started by saying Mgala muwe na haki yake umpe. But again, I started by saying call a spade a spade. And when it came to calling a spade is a bit... The reality of this thing is that we have to call a spade a spade. Improvements are there, challenges are there. And we laud the improvements, but we must also focus on those challenges so that as the judiciary internalizes these issues, the next report will actually be even better improvement. And when I say that, the reality of the matter is that there are things in terms of what we are having in terms of access to justice, which we must say. You know, we have ensured that we are actually conducting our matters virtually. But the reality of the matter is that in those other courts that we are setting up in outside stations, they rely on electricity. Then you find that many a times, yes, and internet, many a times, there is no electricity as we have been used to in Kenya. And you find that there are no generator backups or any alternative sources of power. So many a times you are there and you have to wait and you don't know how long you will wait. Many a times during just the other day, there is a way that people are suspecting government can sabotage the CTS system. Because during the Gachagua impeachment process, it was actually impossible to file matters. Yet you are not even in that matter, or you don't want to file something dealing with Gachagua. You have a very urgent matter. A building is there's a threat for demolition the next day. But for some reason, because there's the Gachagua issue, you cannot file anything for a record almost 3 days, from Friday to Monday. So it tells you a lot. Actually, it was from Thursday. So there are things that we must be given certainty that this even CTS is actually protected in a manner that it cannot be infiltrated.
All right. Julie, in the understanding of a Kenyan
Yes.
who is looking at this institution as the point of last hope, these are people who are aggrieved and they are waiting and looking upon the court to do something about whatever it is that they are aggrieved about. What does that look like? All the issues that they are raising.
For the people we work with, and particularly the poor and vulnerable people, they have decried that indeed access to justice is not as easily gotten as it is for the people with resources, because we still do not have an operational, I would say, legal aid framework. We have the National Legal Aid Act, we have the National Legal Aid Service, but in terms of legal aid itself and the provision of legal aid, we are having challenges because of the fund. So people still do not have access to a lot of advocates who could otherwise provide legal aid because of the lack of resources. So what do they end up doing? They end up coming to the courts and litigating for themselves. And you find that in certain instances where they do not understand the legal processes before the courts, they end up being very frustrated. You can imagine if the two advocates on the table are decrying frustration in the judiciary, what about the person who is self-representing? So when you speak to the people on the ground who particularly do not have advocates, they will say that there are challenges. Most of them have resorted to actually being involved in the court users committee so that they can directly speak to the magistracy and tell them the challenges that are being faced by the people on the ground so that they can try and attempt to fix them. For example, in terms of long distances, matters being called for mention, yet someone has to really use all their money to come to court only for them to have a mention and then go back. So those are the issues that are currently being canvassed at most court users committees, how to ensure that justice for the poor and vulnerable makes sense. But there's also the fact that a lot of Kenyans right now are feeling as though the judiciary, which is the bastion of last hope, is actually currently not living up to its mandate. And it's a lot of the issues that we have discussed and we will be discussing around accountability of the judiciary, but also how Kenyans have invested quite a lot in hoping that the judiciary can actually be there when it's needed. It was a sad situation when a lot of when a lot of Kenyans asked the judiciary why it was not responding to the matters that were happening in regards to extrajudicial killings, enforced disappearances, abductions, and also the killing of Generation Z when they were on the streets protesting against the finance bill. There was a laudable silence from the judiciary, but again, the nexus of that is that it actually has to be moved. The judiciary cannot comment until it is moved. So you find that the entire justice system at that point in time was apparently failing the people it ought to serve. So if you ask the people, it's a mixed bag. Some people are saying the judiciary is working, but others are saying loudly that the judiciary is not working.
It's not working. And Agri, I wonder where that would lead us with regards to even putting our faith in the judiciary, or will it get to a time when Kenyans will take the law into their own hands? Because if you have to wait for 30 years for your case to be, for a ruling, or to what would you do? Like, if you don't have that level of patience, if you don't have the resources to reach out to the lawyers who can help you put a case across, what do you do? If you feel like somebody may be bribed and you may not get the justice that you're seeking, what do you do? What sort of future are we looking at, Agri?
I think in law, we say that a situation of a state of nature is short, nasty, and brutish. That is where we do not have government and everybody is relying on themselves for self-help. But I hope that as a country, we do not get to a place where we get there. There is, as Morogi has said, there is steps that have been taken. But what I believe and what we believe is that there is a lot that still need to be done for us to get to a place where access to justice is a reality to all. And so from how I see it, we are not likely to regress in terms of going back to maybe the pre-2010 constitution as far as the judiciary is concerned. But I think there is a lot of improvements and cleaning house that is necessary for judiciary to be able to deliver on its mandate 100+%. And I think one of the things that would be necessary for this to happen is the use and leverage of technology. And I think this goes beyond the online sessions in court. I think one of the things that is becoming very important for our judicial officers to leverage is the use of technology in transcribing court proceedings. And so if you look today at many courts, when it comes to issues of transfer of judicial officers, we are facing a challenge of the proceedings being typed. The fact of typing proceedings is something that can take 3 to 6 months in some cases. And so if we have a way, for example, of having court proceedings transcribed, whenever there is a transfer of a judicial officer, it becomes very easy for the next officer to take up the matter and to follow up from where it ended. Now, that is just one aspect of it. The other aspect, when it comes to issues of technology, is in sorting the issues of transport in some of the stations and even some of the police stations and prisons. Because you find that, for example, here in the coast, we have stations that carry a perpetrator alongside the victim in one vehicle when they're taking them to court, because there is no means of transport. And so if you look at the trauma that is caused on the victim by just allow for judicial officers to focus on the more serious cases.
All right. I agree. Thank you for saying that. We need to relieve the judiciary of some unnecessary pressure. We'll talk about the alternative ways of doing this shortly. But just coming to you, Kamande, something he has said concerning we probably is looking at a future where we may not regress. But a concern from the Chief Justice herself, Martha Koome, a 2017 judiciary-led justice needs and satisfaction survey that revealed that only 10% of Kenyans with disputes sought court-based solutions, and 19% took no action to resolve their issues, citing cost, complexity, and time as barriers, while 71% of Kenyans turned to alternative mechanisms. You see the point I was trying to put across? This is coming from the CJ. It's coming from a survey that was done. I mean, what are your sentiments with regards to how the future looks like?
I believe the future is alternative justice system. That's
where we are going.
Yes. And, you know, it's unfortunate, and I would not want to label Kenyans as being litigious. But there are matters you find in court that can easily be resolved by the parties themselves through those alternative justice systems. When you talk about those petty offenses, some of those petty offenses are, I sit down with my friend Okach, I insult him, or we're in a WhatsApp group, I insult him, the next thing he's reporting me at a police station. I'm being arrested, court decides that it's going to grant me a cash bail of 50,000 or even denies me cash bail, it grants me a bond of 50,000. Where does it even expect that the same is going to be, that is going to be processed? And it tells you about the reason why you have a lot of congestion in prisons. It is not those big fish that are in prison over big cases, especially in criminal cases. No, it is petty cases. Cases that can be resolved. A person is taken to court for plea taking. He admits, yes. The next thing he's being told is that we do not have the facts, so we are not going to convict you today. Come back next week. What have you done? That is congestion for a whole week. You take somebody to Nairobi remand for
a matter that could just be
a matter that you read the facts. Yeah, court looks at it and says if these parties can negotiate or are willing to reconcile, discharge that person and go. Or you decide, because you have a legacy to keep, that you do not issue cash bail, yeah? That for every offense that comes to you for plea taking, you have to issue stern bond terms. Yeah? So how long, do you know how long it takes for the bond to be processed? Yeah? That is a person who's going to be in custody for all that period of time. So if you look at that perspective, so many people lose hope in those cases.
Yeah.
Yesterday, I will give you an example. Was it yesterday? Yes. Yesterday was in court. There's an accused person who's been caught since 2020. He's in custody. This is we're in 2024. Yeah. Police file has never been brought to court. You do not even have any witness who has stepped into that court. He has never raised a cash bail of 50,000. The court has even declined because of the nature, because he's accused of rape. So the court says that cash bail is sufficient. And you're keeping somebody's son in custody for 4 years without any police file, without any witnesses. Will they ever see any justice in that situation? They'll never see it. And that's the reason why people's perception on the way the judiciary functions is very important. Yeah, because for people, certain people, they have a perception is, I will be arrested, I will go and compromise some people within the registry and all that, and I'm going to be set free. What about a person who is not capable of compromising them? What justice will they ever get?
It's even unfortunate that there is even that possibility of compromising the judicial system.
And I'll tell you, it is not even a possibility, it's a reality.
Yeah, it's even unfortunate that we can even be here, you know, today as a country. We'll talk about that, because corruption and compromising of judges has been a key concern, and also looking at what needs then to be done to address the fear of alienation of the Kenyan citizens from the formal judicial system. What do we do so that we reinstill that trust and that hope that Kenyans should be having with the judiciary? We will be discussing that after the break. Allow us to take a very short break right here on Daybreak. We invite your thoughts, keep them coming, the questions you have, the concerns you have about delivery of justice in the country at Citizen TV Kenya, at Safin_Aching. The hashtag is Daybreak.